Generally, before we can start discussing a class involving law, you should have a general understanding of what the American legal system is and the judicial system. But I'm hoping that you have covered this extensively in a Business 1 type class. I know I teach it in my class extensively, usually taking a better part of a week to a week and a half. So I'm hoping this is going to be review, and I'm going to work through it rather quickly. The CPA exam does not test on the American legal system per se with specific questions. However, there's a basic understanding that you should know what the laws are and where they come from. So let's kind of work through this quickly. What is law? I like to use this definition: rules that attempt to guide human conduct and a set of governmental sanctions that are applied when the rules are violated. It makes sense. But where do these rules come from? Where do these laws come from? And there are 5 areas of where these laws come from: the common law, equity law, statutory law, constitutional law, and from executive orders and administrative rules. Now, our common law and equity law you may see in readings kind of combined together. I'll explain why they are combined together once we work through them. I like to separate them because they kind of have a different sort of purpose. So let's start with common law. Common law is what we call judge-made law or jurist-made law. It stems back from England, developed as a single body system of laws that are made from jurists and from judges. This is to distinguish from church-made laws, which existed back then. America has kind of adopted the laws that have developed through England, and I will say that some of the real estate laws in our country and are still being used today. If I've had an experience where I've had to write a brief regarding a property issue in a border boundary line dispute, and I was digging really old law up from the early 1900s and the late 1800s. It's still very relevant today. So how were these created? Where did they come from? We just talked about that. Developed in England from the 11th century on. And they're usually the foundation from how people have handled situations and their customs. And what happens is judges will look to these cases that have happened over time and consider them to the facts that might be facing them right now, or to resolve any current issues. And these decisions, these prior decisions that have happened over time, is called precedent. And this is a very key word in our legal society and in laws, what the judges will use when determining a specific type of case. And it could be any type of case. It could be a contract dispute, it could be a real estate dispute, it could be a bankruptcy case. In any dispute that comes before a court, they are going to first look at precedent. Another word for it is called authority. And this is the rule that has been established by a prior court or a court in a prior case. And it can be referred to as guidance in deciding later cases. And the Supreme Court is pretty adamant about referring to precedent. And looking back at precedent, you will hear that word used a lot in the legal system. But can it ever change? Once a law is made, can it ever change? It certainly can. Generally, courts will follow it. They like to have a guidelines. Why? Why would it be important to follow it? Why would precedent be an important concept? I'll let you think about it for a second. Why would you think precedent is important? It keeps things consistent. God, if we had to go to court and have a decision that could be anything, not be able to look back on something, we kind of it gives people something to know. If you go and you have an issue, you'd want to know. You'd go see your attorney, or an attorney will look back and say, well, this is what courts have done in the past. I can tell you that's probably what they'll continue to do here in this case. It gives us guidelines. It gives us a standard, but it can be changed. And I want to share that funky little word right there in the middle of the screen, stare decisis, it's called. It's our Latin word for precedent. Let the decision stand. So it has happened in the past. Let it stand. Look to it. But we know that can't always be the case. So there are some situations where the courts can maybe not follow precedent. And their options could be to follow it, to modify or update it in some fashion, distinguish from it, or overrule it altogether. Now let's kind of work through an example. Let's say that you're in a contract dispute. You bought a used car from me. You pay me $1,000, and then you drive off. And the next day, the car breaks down. You want your money back. And I say, too bad, so sad. Sue me. So you do. And your attorney comes to court with a case, a precedent case involving a contract dispute with a dog breeder. Someone paid $1,000 for a purebred puppy. The next week it died of a genetic disease, and the court found in favor of the dog buyer. So that's your case. But I come to court with a case, a precedent case. Or I say it's precedent, and the court should follow this. And my court case involves a breach of contract over a piece of real estate. When the buyer wanted his money back after he moved out of the house because the boiler broke. So this buyer bought a house, the boiler breaks down, and now the buyer wants his money back. And the court found in favor of the seller. And the court also said the buyer had a duty to inspect. So the question is, which case should the judge follow? And should it follow? It certainly could. It can pick one of those and say it's applying precedent. It can also modify or change it and have a different reasoning set forth as to why it's doing what it's doing. And it can say, you know what, neither one of those apply here. I'm going to do something, and I'm going to say why neither one of those apply here. I'm going to distinguish, and I'm going to do something different. But the court could also say, that's old. We're not going to follow those anymore. We're going to do this in this situation. When a court overrules a case, it's usually based on something that maybe it's old. Maybe we're talking about a case from the 1800s, and here it is 2020. So that has a bearing. The times, social situations, court's own point of view can make a court rule or overrule a particular case. But I don't want to lead you to believe that this happens often. I'm going to say what happens often is that they apply precedent. Courts here today, I've gone to court, and the courts will always ask me, what's your authority, Ms. Fox? What case do you have that supports your position, Ms. Fox? Like they want to follow precedent. There's not a whole lot of courts that say, you know what, I'm changing that. And when those things do happen, when a case is overruled, it's usually from a very high court, such as the Supreme Court, or a very high-level court in a particular state. But I want you to know that there's options, and not once a decision is made, that's the final stamp on it. So with the example that we just kind of went through, think to yourself, there's no right or wrong answer. That was just an example. So think through it, rewind back, and see which one you think a court should rule on. Which one of those cases is more similar to that particular situation. So, as I said, why would a court overrule a case? Social values and the mores have changed. Judges on the court and the higher courts do the overruling. Now, when I say judges on the court, I mean like a court where there's a full panel, and that's usually a court like the Supreme Court. That's the one we're all familiar with, but the higher level state courts have a panel of judges. And certainly their points of view, and if you've watched the news involving our Supreme Court, you know that it's in a situation where it will tend to lead more conservative in its decisions versus liberal. Obviously, the choice of which justice should be on the panel is a very big decision of the president. But we'll talk about the Supreme Court in a little bit when we get to the judicial system. Right now we're talking about the sources of law. So where do you find common law? It is in hundreds of thousands of decisions that are handed down by the courts over time, and you can find them by doing a search. Well, they have searches, specific types of search engines. LexisNexis, Westlaw, SUNY Plattsburgh actually has a feature or an app through the library where you can search decisions, Nexus I think they call it. But you can also, now with the advent of the internet and what's out there, Google Scholar, there's findlaw.com. So there's a lot of places where you can find the common law. If you know the name, or if you know what's called the citation, there'll be, when a case gets named, there'll be like a phone number, we'll call it. It's an address that you could type in and it will come up. So that's where you find the common law. And the remedy, so our contract case that we were just talking about, if the court was to rule in the buyer's favor, your remedy would be $1,000 or money. Damages, they call it. Under the common law, you get money. Show me the money. You're seeking to get reimbursed your money or getting paid for how you were wronged. So when we're talking about the common law, we are talking about money. And I stress that because that's our key distinction when we talk about equity law. Equity law is, let's think equal. Let's make things equal. It's a law that allows relief only when money is insufficient or inadequate to put the person in the place where they need to be, had this, whatever the issue is, hadn't happened. It comes from the same place as common law. It's judge-made, stems from England, and has developed over time. It's exactly the same basis as the common law, except common law is money or damages. Equity law is going to be equal relief, and I'll tell you exactly what that means. Coming up, it means fairness, and it's going to address the concerns that fall outside of common law. So let's talk about what they are. This is a pretty big slide with a lot of information. So what can a court do if money is inadequate? How this works is you get this thing called a restraining order. I'm sure you've probably heard that term before. You probably heard it in regards to domestic violence type cases. That's where they're extremely big. It's not called equity law there. It's just called a restraining order. For purposes of a single civil case, and I'm going to give you an example so then we can work through these three bodies of relief that you can get here. So let's say that, I'm going to give you two. One is, I have a song, right? I wrote a song. I haven't played it for anybody yet, except for Disney, because Disney's going to give me a great deal. They're going to use it in one of their movies. But let's say we're sitting in a classroom, and you guys are all sitting there, and I play you my song, and you like it. And you are designing this online company and it needs a good theme song, and you decide you're going to use my song, but you don't ask me and I don't give you permission, and you use my song and I find out about it and I'm really upset because I want to sell it to Disney. What is my relief? What do I want to do? I want to stop you. I want to stop you from using my song. That's one example. And let me give you another one involving real estate, and then we'll kind of work through the two together. Let's say we are neighbors. We have Our houses are built on, I'm going to take Lake Champlain. We have great views of the lake. You decide you want a bigger privacy fence between our houses because maybe we don't like each other, and you build this very large fence, and now it's blocking my view of the water. Do I have any recourse for that? I sure do. It's based in equity law. And when we get to the property topic this semester, we're going to talk about a concept called nuisance. So I can bring an action for nuisance, and my request is, judge, don't let them build that fence, right? Take it down. Stop them from building the fence. No money is going to save me whatsoever. It's going to bring my property value down. I'm going to want you to stop building the fence. So here's how it goes. Go to court. In either situation, I would go to court. I would be the person bringing the case. That's called a plaintiff. We'll talk more about that in a second. And the first thing I do, I don't even have to tell you, I go to court and I ask the court, judge, give me this temporary restraining order. Stop them right now. They're building the fence. They're, using my song. Like, I need this stopped right now. Like, right now it's got to stop. The court will, based on what I've written and what he's heard without hearing from you yet, the other side, will, and if it's established, I establish what I need to establish, the court will give me what's called a temporary restraining order. But it's got a very short run, maybe a week or two, and I'm supposed to serve it on you, the other side. And in that order will also be a scheduled date for everyone to go in so he can hear a little bit more and get some of the other side. Won't hear everything, just kind of see if he's going to extend his restraining order a little bit longer. So we go to court. So I got my temporary restraining order. It's about to expire, but we've got our mini court date where the judge will hear more information and now be able to get the other side. And if the court agrees with me, he'll give me something called a preliminary injunction. And it's the order that the court will, I'm allowed to have it, not indefinitely, but for the length of the case until the case can have a full-fledged trial. So there is no deadline, there is no date. It's just that when the court actually has a trial and the case will come to its complete end, I will have this thing called a preliminary injunction, which means you can't use my song, you can't build your fence. And then the next thing, the final thing, is there'll be a full-fledged trial or hearing, and if the court agrees with me, it will issue a permanent injunction, which will be an order permanently telling you you cannot use my song ever without my permission. And neighbor, you can't build your fence to block my view of the lake ever. It's done. There's no way around it. So that's how that equity law works. Clearly, in either of those situations, being paid, having money isn't going to help. Now you might say, well, they used your song, wouldn't you want some money? Sure. I might ask, hey, well, you know what? You used my song for a couple months. You should pay me for that. You should, but that's not my bigger issue. My bigger issue is I want to use the song for Disney. So I want it stopped. Nobody else should be using it. So that is our law in equity, and this is what has to be proven for me to get it, to get the relief that I want. I must show that I'm suffering a serious, irreparable wrong. There's no other way compensation is available for me to get any relief here. That's my test. That's what the judge is looking for each time he or she is ordering a temporary restraining order or a preliminary injunction or the permanent injunction. Now I want you to think of these remedies as they're preventing something, stopping someone from doing something before they do it, preventing it, or I'm prohibiting something, I'm stopping the doing of something that is currently being done. Our copyright song was prohibitive, and my nuisance with the fence is preventative. I'm trying to stop that from going up, and I want to prohibit you from using my song. And that's the example for the two of those. So that was equity law. We have common law, we have our equity law, and now we have our third source of law, which is statutory law. And what is it? and where does it come from, and how does it differ from the common law. So these are laws that are created by elected legislative bodies, and they could be local, state, or federal. And they're bodies of law. They're called statutes. And some of the characteristics in dealing with those, they deal with problems that affect society or large groups. They can also, when we have statutory law, there's two things that our lawmakers can do. They can anticipate or pass these laws anticipating that something could happen, or they can pass these laws in response to something that has happened. They're like, oh, there isn't a law for that. And we see that a lot. It popped into my head. I know this is not a criminal law case, a class, I mean. But to hit this mark home is the laws involving drugs. We have, up until recently, we didn't have drugs involving the creation of methamphetamines and making it a law not to possess it, or heroin. Those have all changed over time. The same thing with identity theft. 30 years ago and in the 90s, we didn't have the internet. So using the internet or the computer for identity theft and cyber crimes and all of that is new statutory law that had to be created to either anticipate problems or things were happening and there wasn't any laws to protect people from it. So that's where our body of statutory law is important, and all criminal laws are statutory. For this class, business law classes, the Uniform Commercial Code that we're going to talk about in our next topic in contracts, but it also covers things like secured transactions and negotiable instruments are all found in statutory law called the Uniform Commercial Code. Our bankruptcy laws are also statutory laws, the securities laws for the Security Exchange Commission, and the EPA and the environmental laws. So those are all statutory. There's tons more. These are just some examples. So that is our statutory law, and we're going to be using lots of those in this class. Where else do we find laws? Constitution. So where do we find the Constitution? We all know about the federal Constitution, but there's also state constitutions. There's also city charters that are considered constitutions. They provide the plan for the establishment of how the government is going to be operated and organized, established. It outlines the government's duties, responsibilities, and their powers. And they do outline the guarantees that we have as people inside the United States, as taking the federal one, or inside the state of New York if you're in the state of New York, and if you're in Plattsburgh, the city charters, or wherever you may be sitting. But they guarantee our certain basic rights. Now I want to point out, and I'm going to ask, who does the Constitution apply to? It applies to the government, federal, state, city. And what does it protect? It protects, I used to say citizens of that state or of that of the country, but let's think of our federal Constitution. To hit this point home, is it protects anybody who is on U.S. soil, whether you're here legally or illegally. If somebody, and I'm going to take the criminal concept again for being able to understand this point, if somebody is here in this country illegally, let's say they crossed into the border from Canada, happens all the time, by the way, and they are caught, they get arrested, and they have to go through our court system. They are guaranteed the same protection and rights as we have if we were arrested for allegedly committing a crime. You have the you have your rights that are outlined in the Constitution to counsel, to jury trial, and so forth. You have those rights. So if you are in the state of New York, if you are in the United States, you are in the city of wherever, if that's Plattsburgh, you are guaranteed those freedoms that are outlined in those specific constitutions. So where am I going with that? All right, let's talk about the U.S. Constitution. It is our supreme law of the land. And if any other law in the country conflicts with it, it is unenforceable. Now you might be saying a law might pop in your head where you think it does violate the U.S. Constitution. And yeah, the states do attempt to pass laws that violate the Constitution. It's happening right now, all in the South, knowing that we have a conservative United States Supreme Court passing laws restricting abortion. And every time they pass a law, there's a group or somebody files an action, and it has to make its way up through the court system to ultimately get to the Supreme Court to determine whether or not it's constitutional. And as you can probably imagine, that takes a very long time. But in the meantime, these folks, these groups, are going to court asking for injunctions. Say, yo, court, stop this. Let's stop this from passing until we get an affirmative from the U.S. Supreme Court, or until some higher court rules this constitutional or unconstitutional. So that's how it works in this general sense. The Constitution itself is very hard to change. There are only 27 amendments. The last time it was changed was in 1991, where basically it said the House of Representatives cannot give themselves a raise during their election year. It's a very weird amendment. The important one, there's tons of important ones, but the first ones right out of the gate were the Bill of Rights that codify our rights. We won't go through all of those, but you probably got that from a history class in high school. But not only do we have the constitutions itself, we have an extensive body of law that's developed over time from the courts. The Supreme Court, and we'll talk about some other federal courts here momentarily, they review the Constitution. They have to interpret the Constitution. So not only do we have the Constitution, we read it at face value, we have the courts that are interpreting the Constitution, hence passing laws regarding the Constitution. So there's this extensive body of law. Will we get into constitutional law in this class? I believe not so much. I think the only area where we touch on the Constitution is during business organizations, where I'm going to tell you, spoiler alert, I'm going to tell you right now, that corporations have constitutional rights. And I'll go into that in more detail when we talk about corporations. And then our last body of law, I have two under one. I kind of lump them into this one section. Executive orders and administrative rules or laws. So where do these come from? Executive orders, if you live in New York State, you're hearing about the governor passing a whole lot of executive orders as a result of us being involved in the COVID-19 and dealing with the coronavirus. The president is very active in passing executive orders. These are rules of law that come from the highest executive, whether we're dealing with the governor of New York State, the president of the United States, or some mayor in a city, etc. They can pass executive orders. Can they be overturned? Sure. What happens is they go to court over it, and the one that sticks out in my mind most recently is that the governor had passed a executive order canceling the New York primary with the idea that the Democrat primary with the idea that Joe Biden was going to be the sole winner, so to speak. And the other politicians filed the court action, and the decision was, yeah, you can't do that. So the primary has to happen, and it did happen. As this recording, it's after the primary date. But no, just because they pass an executive order, it doesn't, bad pun, doesn't trump all. So they have these, powers and the rules that they're allowed to do those executive orders, but they're not without challenge. Administrative rules, these come from the government agencies. They're created by government agencies. They usually deal with very specific or technical, complicated areas involving expertise. The panel for the organization or the agency that oversees any violations of administrative rules are appointed by government officials, but they have an area. They're an expert in the area. Their laws are specific to that area of law. I'll give you some examples, and then I'll jump back up. The Federal Trade Commission is an administrative agency with its own rules and governing body that can violate violators and take them through their mini court session. The Securities Exchange Commission, the Environmental Protection Agency, the Trademark Patent Office, I think I said the Federal Trade Commission. Those we're going to actually talk about that group specifically in this course when we talk about consumer issues. They will go after, or they don't make arrests. What they do is they file a petition, and they have to come to court, and they can fine them, businesses who might be involved in deceptive business practices or false advertising. And I have some more specifics about that when we talk about consumer issues later on. So, but that's not without further review. They do have their own appeal board, so they have a panel of judges who make a decision, and then that can be appealed to a higher appeal board. And if you don't like that decision, you are free to take it to a court to review the action of the board, but the court's review is extremely limited. So those are our 5 sources of law. What I'd like to do is jump into the judicial system, do a quick overview of our judicial system. There are generally a judicial system for each state and the DC. DC has its own court system. And we have ultimately, even though the United States Supreme Court is treated as a federal court, it is actually the Supreme Court of the land, and it does oversee state cases and state proceedings as well. So generally, kind of work through the court system here. Generally, each system is divided into 2 distinct sets. Your case is going to start in what's called the trial court. And the trial court hears everything. This is the first court to get a case. If I want to file my nuisance case with the high fence building, or my copyright law case involving you stop using my song, I have to start in a court, and that court is the trial court. And this court hears everything. They're going to hear what the facts are, and they're going to hear what law they're dealing with, i.e., that's the law that I bring to court, what I think the precedent should be. So, what types of information, or where do facts come from? Think about that for a second. Where do facts come from? If you're sitting in court, you want to get some information out there, where might it come from? Well, it comes from witnesses who I might have come and testify. It might come from documents. If we're dealing with a contract case, I might bring in the contract. Might be in the form of photographs. I'm taking a picture of you building your fence that's supposed to be really high and block my view. the song itself in the copyright case. It's all the information you want the court to have in order to make a ruling. So evidence, as we call it. So that's our trial court. The trial court hears the case. And the loser of the case has the opportunity to challenge that decision by going to a higher court. And the higher court is an appellate court. And the appellate court isn't going to rehash the whole case all over again. That's not what they do. They will only determine if there was an error relative to what the court did. And anything the court does is called a question of law. The facts are what happened. The facts is, here's my contract, this is what I said, this is what this person said, this is what the witness said. The facts are what happened. The law is what the court should do about it. So in essence, the appellate court's going to take everything that was heard or what happened and determine whether or not the trial court made the correct decisions on the law. They're only going to hear the questions related to the law, not everything else. Our state court system is generally set up like this little hierarchy. As I said, 50 states and DC have at least a lower court and an appellate court. This is the general structure. I'm going to show you New York's structure here in a moment. But normally there's some municipal court or traffic court. And those are all the smaller type cases, speeding tickets, maybe a noise violation, maybe a disorderly conduct, maybe a small claims over somebody sold somebody, let's say a bad lawnmower for $200 and they want to battle over it. It would be down in this lower traffic municipal court. And then they sometimes call it small claims court. Superior court, that's our trial court. That's where I'm bringing my nuisance case. That's where I'm bringing my copyright case. That's where I'm bringing my breach of contract case, is in the superior court, the trial court. That's the lower court, the trial court. In most states, they call it a superior court. The appellate court is generally called a Supreme Court. The state of Vermont has this set up. The state of Connecticut has this set up. The state of Massachusetts has this set up. The Supreme Court is the highest court in the state, their appellate court, and they're going to determine those questions of law. Now, you can go, the loser of the Supreme Court appellate court case of the state can go to the United States Supreme Court. They can ask the United States Supreme Court to hear their case. But it has to be one issue only. The issue being it has to involve a federal question. They won't hear a state contract case or my nuisance case, possibly not my copyright case, unless I claim some violation of my constitutional right. That's what they will hear, a federal question, constitutional in nature. That's all they will hear out of the state court. I kind of already went through this in my last slide, so I won't rehash it here. It's the general outline of the lower courts. A couple things I want to point out. There could be a jury, and this is where you would find the jury in the trial court. There is no jury in the appellate court. And there are some examples of cases: evasion of privacy, libel. I should point out that that the facts of a case, like I said, is what's called, in the end, is what's called a record. It's the document that's all put together. That, if you're familiar with a court, maybe you've seen court on TV, but there's somebody who sits in front of the judge taking everything down, the court reporter, the stenographer, they call that person. They're creating that record, and they're the keeper of the record, whether there's documents that have come in to be shown to the court, or somebody's testifying, or there's photographs. They keep all of that, the keeper of the record. And then as our Supreme Court, like I said, don't rehear the case. They're going to be the final authority on the case law. And this diagram is the New York State court system. A couple things I want to point out here, if you see straight ahead in the blue / half white box, Supreme Court, that is our trial court. That's our lower court. This is where I'd bring my nuisance case. This is where I'd bring my copyright case. If it was a state matter, we'll talk more about copyrights later on. This is where I'd bring my libel case, my invasion of privacy, my breach of contract, right here, Supreme Court, right dead center. As you can see in the other branches, the little purples below, those are all the traffic / municipal small claims courts that I talked about. And then there's kind of a separate branch that specifically deals with family court. County court is all felony criminal cases. Surrogates court involves wills and trusts and matters involving guardian ad litems. Court of claims, the other purple on the other side of the blue and white box, the Court of Claims, it says, those where all the cases, if you want to sue the state of New York, that's where you have to bring all your cases to the Court of Claims. So our trial court we're focusing on is the Supreme Court / appellate term, as they call it. The appeal division is right above. They call it the appellate division. And there's 4. We have 4 of those in New York State. They split the state up. 1, 2, 3, and 4. 4 is the western part of the state. 3rd is the Albany and up through the North Country. 1 and 2 are split between New York City and Long Island. But New York also has yet another level, Court of Appeals. So if you don't like the decision in that appellate court, the division, the appellate division, you have one more bite at the apple to go to the Court of Appeals. But they take very few cases. And it would have to be a serious question of law. So that's how New York State is structured for their court system. The federal court system, very similar, just like they have a federal system in each of the states and DC. And it's set up very much like the state system. You have a trial court. You have an appellate court, and then you have the United States Supreme Court. The district court, that's the one that hears all of the facts of the case. They get everything, and the courts make the decisions relative to law. If the loser does not like the decisions, they can bring their case to the higher appeals court, the U.S. Court of Appeals, and then from there to the Supreme Court. The Supreme Court hears a few more cases out of the federal court system than it would out of the state court system, but generally they've been preferring they take like 100 cases a year, a very small amount when they get thousands and thousands of applications to take a case. So they tend to lean towards federal questions or a question involving the Constitution. But I want us to make a point down here with district courts. This is our basic setup. In bigger states, their districts are branched out. They may have more than one. There are 4 in New York. We have the Northern District, just like how the map of the state, they have the Northern District, the Southern District, the Eastern District, and the Western District, and they all take a part of the state. And the circuit courts, there are 13 circuit courts. There's not an appeals court in each state. The circuit courts are lumped. They'll have 3 or 4 states in a circuit. For this class, it'd be nice for you to know that we are in the 2nd Circuit. New York, Connecticut, Vermont is the 2nd Circuit. And then if you're in any of the other states, you can do a Google search to see which circuit you're in. I know it's California, Arizona. Colorado is the 9th Circuit, which is the 9th Circuit and the 2nd Circuit are 2 of the biggest circuit appeals courts. And then I just have a nice little diagram here because I want to point out one other thing. The bankruptcy court. Bankruptcy court has its own court court just for bankruptcy. It has its own code, its own statutory code, as I just explained a little earlier. It is considered a district court, so if there was a challenge out of that court, they would appeal. If it, let's say it happened in New York, they could appeal it to the Second Circuit. But I wanted to note that specialty courts, there's a couple specialty courts, but the only one that we are concerned with for this court, or this class, is the bankruptcy court. Types of cases that the federal court hears. There's 7 different versions. The only 2 that would concern this course are 1, cases that arise under the U.S. Constitution, because I keep bringing up the Supreme Court, but more importantly, number 7, cases involving controversies between citizens of different states, and the amount sought is over $75,000. Breach of contract case. If you entered into a contract with somebody in Vermont, and it's for $1 million, $1 million contract, and there's a dispute, going to have to be in federal court somewhere, whether that is in Vermont or that's in New York. That's an entirely different decision and not something you need to know here. You just need to know that the federal court is very limited in what it hears its cases on. Real quick, lawsuits, types of lawsuits. There's 2 different kinds: civil lawsuit and a criminal. It's called a criminal prosecution. It's not called a lawsuit. Civil lawsuits, that's what we're dealing with in this course. Contracts are a civil case. Secured transactions is a civil case. It's a type of a contract, but it's a civil type case if there was a dispute. Negotiable instruments. Bankruptcy is a civil matter. Those things is what we're more going to be concerned on when we talk about consumer issues. Civil. I don't believe we're going to be talking anywhere in the criminal world, but I want you to know the difference between the 2. The person who brings the corporation that brings the lawsuit is called the plaintiff, and the one being sued is the defendant. So how do we get started? Let's talk about the nuisance case from the beginning. If I want to sue you and stop you from building your fence blocking my view of the lake, I get to pick the court. Let's say we're in New York. My low court I'm going to pick. And if we're on Lake Champlain, let's say we're in Plattsburgh, I am going to pick the Supreme Court here in Plattsburgh. Could I certainly pick the Supreme Court in Albany? Sure. And I could pick the Supreme Court in Syracuse or in Utica, but hey, it's nice and easy. We're both in Plattsburgh. We'll pick Plattsburgh. I do that by filing a piece of paper. It's called a complaint. Sometimes they call it a pleading. And it says why I'm here. And I say, I'm bringing a case. It's called, the typical name would be nuisance. It could be, if I wanted to file breach of contract, if we had a contract abuse dispute, my case would be about breaching a contract. I had a contract with A. A breached it by doing blah, blah, blah. Now I want my money back. That's the gist of a complaint. So what happens next is that I have to serve you with it. Otherwise, you don't know you're being sued. I get you served. You'll have time to respond per what it says in the document. And then the court will bring us all in. This is a very general outline of what happens. There might be 3 or 4 different conferences where the court's going to try and determine whether or not there needs to be a trial or whether people can agree on something. But if there's a trial, I have to prove it. I'm the one who brought the case. I have to prove it. And I have to prove this by our standard of proof, which is called by a preponderance of the evidence. Now, I want you to think of a scale. If you put your hands out like you had a scale, if you just put one little weight on one side, it just tips up a little, slightly. That's how much proof I have to put on. I just have to tip the balance just a little in my favor. And if I win, if I do that, the defendant is found liable. We don't use the word guilty in civil cases. Found liable. But when I'm done presenting my case, the defendant gets a chance to say their side. So you'd be able, on the fence case, you'd be able to come in and say why you're allowed to build a fence. If neither party is happy with the outcome, what do we get to do? We get to appeal. And then a criminal prosecution, the case is brought by the government. In a civil case, we have two private parties, me and you, private parties. When you have a criminal prosecution, the government's coming after you. You might hear the term people of the state of New York or the U.S. government, the United States of America versus Smith, people of the state of New York versus Jones. Whenever you see a state or government name the U.S. or New York or Massachusetts or Connecticut, you think criminal prosecution because they're the one bringing a case against an individual. How does that happen? Well, somebody gets arrested. They have to come, how do you find out there's a criminal case? You get arrested. Sometimes you get handed a ticket, but you have to go to court and you have to have your charges read to you. It's called an arraignment, and that's where I see on TV and crime shows somebody pleads guilty or not guilty. And then the court schedules and holds a conference, a pretrial conference. And like civil cases, there can be a settlement. It's called a plea offer or plea agreement, where somebody agrees to plead guilty, maybe to a lesser charge, get a little lesser sentence. That can happen. That does happen a lot of times, more times than trial. But if there is a trial, the government has to prove the case. And they have to prove the case, and you probably have heard this term before, beyond a reasonable doubt. Now, if we're back to my scale, got your hands out on a scale. That scale has to go way up on one side. That's the burden that the government has. It's got to be way up. Reasonable doubt. There's always a jury in a criminal case. The defendant can opt for a judge or a bench trial, they call it, but that's rare. There's always a jury. In a civil case, you do not have a right to a jury. You have to request it, and you actually got to pay for it. It's a lot of money. So the jury verdict has to be unanimous in a criminal case. In a civil case, a majority. And rather than a court saying, take down that fence or pay $1,000 on the breach of contract, the judge in a criminal case poses some punishment or sentence. The whole point of criminal prosecution is to protect society. We do these, we have these for the protection of society and hopefully deter crime. So anyway, we don't need to go off and divulge, get into civil or criminal cases in detail. I just want you to know there is a difference between civil and criminal, and we're going to be dealing with the civil side of things. So that's my quick overview of the American legal system. Kind of buzzed through it. Like I said, I would hope that you had covered this in great detail in a Business 1 class. There's also a chapter on it in the 2 books that are available if you want to look back over it. And we're going to jump into contracts.